ladies and gentlemen. We have today a very distinguished panel, and I've asked each of the panel members to speak for 10 to 15 minutes with an opportunity for questions immediately afterwards, and then to form a panel to have a more broad discussion with everybody who's in the room here. So hopefully everybody who wants to have a chance to ask a question or to make a statement will get the opportunity. So in a slight change to our order, the panel members are Louise McElvogue. Louise is the director of McLeod Media and also in the last year sat on the Convergence Review. Peter Leonard. Peter's a partner at Gilbert & Tobin and my former boss. Jane Van Beelen, who's Executive Director of Regulatory Affairs at Telstra. And Greg Houston, who's the one of the founding partners of Houston Kemp, an economics consultancy. So I'll start off by asking Louise to give some remarks.
Yeah, thank you very much. I'd just like to say actually it's quite sweet. The bio in the handout says I'm still working on the Convergence Review, which watching Professor Harper in there, I was having flashbacks. It does feel like I am still there in some ways. First, can I say I'm not a lawyer and I'm not an economist, so I might be the least qualified person in this room to talk to you about competition law and IP policy. But I think I'm here to give you the practical view of what it's like to work in digital disruption, trying to work around the current regulation and rules as they stand. So I thought it would be useful for you to talk about some of the challenges of digital innovation, working with current IP regulation and competition laws, some of the changes being brought by new competitors in this space, and finally what the Harper Review suggests and what that might look like into the future. So first to digital innovation. I've worked probably for the last 15 years in all sorts of internet, building websites, digital transformation, digital disruption. But I'm just going to focus on a slice of it today that might be relevant, which is everything I've worked on that's to do with copyright and video on demand, because it seemed particularly pertinent from what I read in the Harper Review. So I came back to Australia 6 years ago, and I just finished building 2 video-on-demand sites in the UK. One was for Channel 4 and one was a Netflix-style aggregation service that was backed by the 3 biggest broadcasters in the UK. And when I came back to Australia, it was 2008, and the ABC was just launching iView, which I worked on as a consultant and I've worked on and off over the last 6 years, along with a whole lot of other stuff. I think the reason I wanted to mention those services is because it points to how little has actually changed in those 6 years in the Australian video-on-demand market. So it is a tiny slice I'm talking about, but just to give you an idea about how things probably haven't moved on that much. So while everyone's very proud of the early adopter status of Australians in terms of technology, we've got a lot of very smart devices, but not much content to watch on them, or not much legal content at least to watch on them. So, why are we only now seeing truly aggregated VOD services coming into this market? In 2015, we'll see a Netflix launch, we'll see Channel 9 launch a service along with Fairfax. There is a service from called Presto from Foxtel, which will relaunch next year, probably with broadcast partners. But you have to ask the question, why has that taken so long? This is a market with one of the lowest pay TV penetrations in the developed world. It's under 30%. So 70% of the population are surviving on free-to-air TV diet plus the video store and legal content. I think a lot of that is down to competition and the copyright policies that exist, but also the protection of existing business models by the broadcasters and the content owners. So as is clear in the Harper Review and the recent Senate review, Australians have access to much less content. It takes a very long time to get to us, if it gets to us at all. And when we do get it, we pay way over the odds for it compared to anybody else. So just to talk for a minute about the challenges that presents when you try and build a new service. The way to design a product, any product, but particularly a digital product, is to look at the way the audience uses things. Everything about what they use now, how they might like to see it in the future. And this is what the customer-centric approach to designing products is about. And at the heart of digital disruption is, the networked effect is I can go globally and get anything I want when I want it. So it's no longer waiting for the business to release what I want it to release, I can get it from anywhere because of the internet, simply. And when you design a VOD service, effectively you've got to ask all these questions about how you design it around a customer. Do they want a series all at once, or do they want it week by week or day by day, release an episode each time? Is it better to stream the content or download the content? How do you make it so I can watch it on my desktop at work, stop it, and then watch it on my tablet on the way home and on the train? Now, with most products, making sure that your service works for the user is easy, but with digital content, you have this patchwork of confusing, conflicting rules around copyright and competition that make it unbelievably difficult to build. So if I think back to those services that I've worked on, different rights holders have completely different rules. One will let you stream content, one will only let you download content, some will only let you progressive download content, which is sort of somewhere between, well, it's really a stream, but it's sort of a download. Some people let you use it on 5 devices, some people let you use it on 1 device. Some content owners will let you have 10 users, some will let you have 1 registered user accessing that content. So I've spent many hours in small rooms with tech teams trying to design services that, one, can work within this copyright framework, but also are something that a user would want to actually use in any sense. So to be fair, today that's got a little easier over the last 6 years, but it still is quite difficult to design within those frameworks. And in those intervening 6 years, Australian media has been painfully slow to adapt to video on demand. And I get that from a business point of view. A lot of these people are my clients. We still have very robust audiences for free-to-air TV. We have, I think, the second highest per capita advertising in the world on free-to-air TV. And the rates, the ARPU rates, the revenue per user on pay TV are also one of the highest in the world. So there is no compunction to push for making changes and making this content available digitally. But as a competition issue, it's very inequitable for consumers. And as an Australian consumer, I'm paying more and getting less under the current setup. And the market effect is that many of us have now worked around these existing rules, and those workarounds that we all use are getting easier and in fact more legitimate. So let me give you an example. 5 years ago, if I read online that Will Gardner got shot in The Good Wife, which I did, well actually I think I read in the New York Times, oh my God, a big character's died on The Good Wife. And I thought, oh my God, I'm not going to be able to see it. And I'm not going to be able to know who it is. Not that I'm that desperate a fan, but it was more actually a general sort of news item than a die-hand fan forum that I was on. Now, I had 2 options maybe 5 years ago. I could go online and try and rip that off, although frankly, the demographic watching The Good Wife, probably there's not a lot of that available, but you can basically get anything if you want. Or I wait till the local broadcaster who has the rights puts it online. Now, what's probably changed in the last 5 years is if I hear that Will Gardner gets shot in The Good Wife, I might be one of the, some people say 20% of online Australians use a service that makes me look like I live in another country. I will go online, I will either buy it or I will stream it from the website of the broadcaster who used it in the US. Now, really, in the Good Wife example, that's a combination of copyright laws. You know, we're selling the international rights territory by territory, and the competitive business practices. So the broadcaster has the rights here, is sitting on them, and that's their right. They want to wait till they're in a ratings period or whatever suits them. And the rights holder isn't allowing anybody else to sell on those rights. So, you know, as a consumer, I'm willing to pay for that rather than wait for it to come on television, but I actually cannot get access to it. Now, the benefits of that market distorting behaviour are eroding really, really fast. So we now have a market in Australia where there's no stigma to illegally downloading content, and we're making our computers appear to be in another country is becoming quite common, and not only common, it's actually encouraged by our consumer advocate groups. You know, Choice wants to educate me in how to set up a VPN so that I get around these current laws. So it's not only consumers that are suffering, but also the content owners. And particularly, I think the local production market will really start to suffer. The different windows of content availability will become less profitable because audiences are finding their ways around the rules, and you'll see a decline in the returns on content. Another point that the Harper Review made in this in this area that was actually particularly about local production was that before we give away any IP rights in a future free trade agreements, which are very fashionable at the moment, there needs to be an independent cost-benefit analysis of what we are doing, because it was only during the convergence review, and I'm not an economist, I'm not a lawyer, I don't know anything about free trade agreements, but I was very surprised when we got to looking at content quotas in Australia. Most of you would know we have 55% content on local content quotas on our free-to-air broadcasters. Within the free trade agreement with America, we are not allowed to drop those content quotas. Well, if we do drop them, we can never put them back up again. Now that seems completely kooky to me, that you would offer that as a condition in a free trade agreement with a partner who is the largest importer of content into our country. So that's one of the Harper Review recommendations that I think was well picked up, and something that we really do have to focus on. So how do we make it better, and what are the review's recommendations? What might that look like? I think the acknowledgement that there has to be an independent wholesale analysis of copyright and competition law in relation to new technologies and markets is really key, because it's not something that you can change piecemeal. And I think that's really important. And the clarity within the review of focusing on consumers was very refreshing. Having sat through the convergence review, having gone around the country and talked to a whole lot of people, capturing what consumers want is the one big piece that's missing from all of these reviews. Everyone wants to tell you what the public interest is, but their public interest is what actually the interest of the person you're speaking to on the whole. But I think what we're also seeing is a bit of change in rhetoric around the whole area of copyright. So even the government's recent copyright discussion paper talked a little bit about there is an onus on making content available to reduce illegal downloading and illegal use. So at least we're seeing some admission that making content available at a fair price in a reasonable time frame is as important, as the carrot, as the stick of, taking my ISP to court. And can I just concur with that view that actually once you offer users legal content, that's what they want. No one wants to illegally download content. I've been building these services for 10 years. Every piece of research when you're building them and after you've built them shows you that that's what people want to do. And I'm sorry, not from a moral reason, from a pure reason that I know the content will be a better quality and I probably won't get some weird thing on my computer alongside it. But time and time again, it does show that the illegal downloading drops. Now, paying for the content is another matter, but we're not really talking about business models now. So my experience working on the government review in the past with the convergence review is the real test will be what the government does with the recommendations. The Harper review and Choice seem to be encouraging circumventing geo-blocking and educating consumers as one approach. And I think it's a good start, but I also think we need stronger provisions on pricing. And I think just attacking it that way will end up with a system that people will continue to work around rather than actually getting a wholesale change, which I think is what the Productivity Commission review, if it's the Productivity Commission that does it, of IP and copyright generally is probably what we need. But also I think we're seeing potentially the market moving more to trans-border services, that we may well end up less with the competition changing the market than actually the competition working around the existing rules. So just to explain that, if you look at Netflix as the ultimate digital disruptor in this area, they started buying non-exclusive windows to television content, and then they moved to buy exclusive windows, and then they moved to making their own content. And recently what they've started to do is buy global rights to content. So global rights to in the areas where they are launched and will launch in the future. So the television series Gotham that's running on 9 at the moment, they've bought the worldwide rights to that. So we may end up that before our laws actually change to, our policies change to allow more access, competitive access to content, they may well be just coming straight from the US with a Netflix service that has global rights, and the other services in local markets that are trying to use these piecemeal packets of rights will really be at a truly competitive disadvantage. So that's probably the best. I'll stop there, just giving you an idea of what I'm seeing from the digital disruptive end of particularly copyright law.
Thanks very much. Any questions other than noting that Lilyhammer Season 3 is available on Netflix? It's going to be a great weekend.
It's a room full of lawyers. I mean, I didn't actually touch on whether it was illegal or not to do it.
I'll take advice later. Any questions for Louise? Yes?
Luke Banhook from Optus. Just a quick question about content and the CCA, or the competition law. We see in the UK now, for example, the regulator doing a market inquiry into the English Premier League and whether they have breached competition law and its way it sells its content. And as you heard comments before that content is potentially becoming the new bottleneck rather than infrastructure ownership. Do you see that the current rules, the current infrastructure access rules in the CCA, and plus either the Harper recommendations, is addressing the content bottleneck issue? Is that a glaring omission in the Act it is and in the recommendations?
Am I going to have to answer that?
Anyone can answer.
No, I think we'll get a lawyer to answer the copyright question, because I'm not that on top of the Act.
I decided I wasn't going to talk about content at all today.
I thought Louise was going to talk about content.
Yeah.
I think infrastructure access is rightly targeted at real bottlenecks. I think there's a distinction between a particular type of content which some consumers will have a preference for, which competes against other content, be it different football codes or different sporting codes or different countries. So I think I wouldn't characterise that kind of content as a bottleneck in the same way as the Act deals with infrastructure bottlenecks. I think we have a competition regulator who can, of course, look at the competition implications of any particular exclusive agreements or any kinds of agreements that rights holders choose to establish or the terms upon which they propose to offer their content. We have similar here where the sports rights holders such as the AFL and the NRL tend to hold enormous amount of power in determining how they distribute their rights. But I'm not sure that an access regime is quite what's called for in that case. I think it's something that if there's a problem, the normal competition law can deal with.
I think there are a couple, because I'm going to have my tuppence worth as well, a couple of issues. Firstly, in the UK case, well, this looks very much like second time around, and the first time around the Competition Commission, I know it'll be the Competition and Markets Authority this time, when Ofcom started worrying about first-run movies, came to the conclusion there was nothing to worry about here. Whether the Premier League will come to anything different when the case is actually structured in an almost identical way, I think is really questionable. The second issue on rights, I'm not an economist or a lawyer, but if I was going to say, well, how could I make sure that those valuable rights that come from the AFL or the NRL are dealt with fairly and reasonably? Well, I might come to say, well, if I deal with scarce resources, I'd probably want to see some sort of fair, open auction process, and that this fair, open auction process should happen on a reasonably regular basis. And shock, horror, probe, that's exactly what happens. Any other questions? Can I hand over to Peter?
I'm going to stand up today, if you don't mind, but Rob, please bash me if I look like I've taken control of the podium and I'm talking too long. I breathe better if I'm standing up, I discover. So I wanted today to do a presentation on digital transformation without using the words copyright, piracy or rights. And thankfully, Louise volunteered to go first and thereby enabled me to make good on my promise to myself. But what I did want to do instead was talk about the new areas of disruption and how we think about them in competition policy terms. And on our way to thinking about the impact of digital disruption in sectors of the economy other than digital content itself, to have a few words about the nature of the competitive advantage that very large providers have in the internet economy itself, and by that today we largely mean Google, Facebook and a few others. And I think that it's useful to sort of start from thinking about what's different about the digital transformation that we're living in today to the kind of competition that there's been around digital services over the last 10 years. And if you think about what we've seen over the last 10 years, the characteristics really are strong dynamic growth with a high turnover of new services and a significant turnover of players in the space, and market concentration characterised by a few overwhelmingly large, increasingly global players, and an even greater imbalance between big companies on the one side and SMEs and individual users on the other side. And there's been a whole succession of companies, of course, that have been in that situation. Some of them now are history, some of them perhaps are nearly history. Yahoo and Alta Vista in search, Palm, BlackBerry and Motorola in mobile applications, AOL, Time Warner in online services. Remember when we all thought that the walled garden that they could create would be impenetrable. So we've seen some pretty significant changes in the last 10 years. And then let's just think about the position of those companies that we regard as, well, to use the word in its non-technical sense, dominant in this space today. Apple introduced its first iPhone in only June 2007. And notwithstanding Apple's closed OS model, 1 year after Apple's App Store was opened in July 2008, 1.5 billion apps had been downloaded for iPhone or iPod Touch, very few of which were created by Apple. Google released the Open Android operating system in 2007, and the first Android phone shipped in 2008. As of September 2013, there were more than 1 billion Android devices activated globally. Yet because Android is free, Google does not generate any direct profit from these activations. Google apps compete against 1 million other apps on the Android platform. Google Maps and YouTube are amongst the 30 most downloaded apps by users of Apple's iOS devices. Now, of course, Google's business model is well articulated. By offering a well-functioning operating system and attractive apps, Google can attract users, and by attracting users, Google promotes its mobile advertising business, including location-based advertising. And further, by bundling together applications into, as they call it, a mobile application distribution agreement, or MADA, for bundled but free installation by equipment manufacturers, the Google Mobile Services Application Suite is conveniently offered as a single product, which includes Gmail and Calendar. So this is, of course, your archetypical two-sided market that today is also being replicated in a social networking context by Facebook. And that leads to the interesting question currently being canvassed by the European competition authorities, and also in Greg Sidak's recent article, which he titled, "Do Free Mobile Apps Harm Consumers?" Really interesting question. So what do we have? We have a few overwhelmingly large, increasingly global players competing in a highly dynamic market. The key questions, it seems to me, from a competition policy perspective are whether and how the large market share of these providers affects their market behaviour, whether their large market share is a temporary or non-temporary feature, and whether these providers enjoy their market position because they're protected from competition through barriers to entry, or rather because they're enjoying the profits of superior technology and innovation. But I think it's important that competition policy isn't dazzled by the light of these stars at the core of the digital economy. The really interesting areas of change that competition policy needs to look at are in many other industry sectors. Some of these are already obvious: job search, hotel and airline reservations, home food delivery, etc. Others are more prospective: Uber, Airbnb, personal health monitoring, mobile payments, and so on. For many industry sectors, there's speculation, to use a Deloitte's analogy, both as to the length of the digital disruption fuse and the size of the bang when digital transformation goes off. And I'm referring to quite an interesting Deloitte Australia paper called Digital Disruption, Short Fuse, Big Bang, which is good reading for anyone interested in competition policy in this space. Now, many of the disruptive changes that we're seeing are data-driven. Growth in most sectors of the economy has been accompanied by an exponential rise in the value of data and advances in data mining and analytics, and a massive increase in computing power and data storage capacity. Whereas previously data had been collected as part of the provision of a particular service, the added value of big data in the potential to uncover new correlations for new potential uses once the data has been collected may mean that the valuable uses have nothing to do with the original purposes for which the data was collected. Way back in February 2012, doesn't that seem a long time ago now, Dan Schulman, American Express's global president of enterprise growth, was quoted in Forbes as saying, this is American Express talking, we're beginning to realise that data is actually more valuable than the payment transaction itself. The reason that Google wants to move in with Google Wallet is not because they want to move into payments. What they really want is the data from that transaction. I say way back in respect of 30 months ago because since that time, over 90% of the data that is now in existence on this planet has been generated, and the output of data is doubling every 2 years. Now, it's easy then to extrapolate and say big data has become a substantial intangible asset and that used for the purposes of value creation, and to say that those companies that have the most data are potentially the most valuable, or that data is a source of market power. But that's not true of itself. Data has to be cleansed, it has to be made usable, and it has to be related to applications or products or services that can be put into the market. And those things are often very difficult and very expensive to do. And data is often highly perishable, flighty, and often device specific. I'll ask the question, how valuable is BlackBerry's data today? With many digital services like email or search engines, which are used by almost every internet user, companies foster the perception that they're provided for free. Of course, as we know, individuals are required to surrender valuable personal information in order to enjoy them. And consumers provide, in essence, personal information as a currency to enable free use of an application. And that becomes very interesting as we move into our next stage of digital transformation, which is the Internet of Things. Today, there are about 6 billion devices connected to the internet. By 2020, estimates put that number at 50 billion. That's between 4 to 7 connected devices per person. And that, of course, is the new Internet of Things, the industrial internet, the Internet of everything. It's got various titles. Now, the key point is not that there is just more devices or that there is more data, but this. Most smart products today are fragmented and don't work together. Data is siloed in each product's separate application, and this will change in the future as devices grow more interconnected. There's going to be some really difficult competition policy issues around that interconnectedness and about access to data streams. Take your telematic car, your connected car, noting that in the next 3 to 5 years, that'll be every car, every new car. Can your car manufacturer reasonably claim all data collected about you as the manufacturer's property to deal with at will? Can the manufacturer reasonably refuse to provide a service port to engine operation data that may be accessed by non-affiliated independent service operators, as distinct from the car manufacturer's authorised service centres? Can the manufacturer reasonably provide driver behaviour data only to its preferred insurer and not to other insurers? Now, these are not novel competition policy issues, and many of them can be solved by the conventional economic analysis that we use in competition law today. But the potential sources of market power are often non-intuitive, highly dynamic, and frequently required multi-sided market analysis. Clearly, consumer welfare, including transparency and customer choice as to privacy and security, are fundamental to any reasonable Internet of Things solution. Issues around ownership of data, intellectual property rights, note I avoided the word copyright, and interoperability and portability of data arise in almost every Internet of Things scenario. And often these issues are heightened because application delivery is in a supply chain that involves multiple entities with roles defined through interoperability or restrictions on interoperability of devices and data streams. So you'll have, for example, the supplier of a distribution platform, the supplier of sensors or other devices that are collecting the data, and readout and control apps and analytic service providers and so on. My point is that in the Internet of Things world, often these services are provided by a cooperative effort between a number of different providers who then set rules around the data sharing, data use and interoperability of the data stream and the devices. The protection of commercially valuable data so shared often requires restraints as to data reuse or use in competitive applications by the selected preferred data providers. And often this deployment is across borders. Of course, the closing of the data stream to other devices or to other analytics providers of itself creates competition concerns. So I think where I'd like to end is the note that digital transformation is a very powerful factor in shaking existing industry sectors to their roots. Often competition will come from sectors or modes of provision of service that are completely outside the existing market, Uber and Airbnb being classic examples. But as we go into the new Internet of Things world, many of these standalone services or single service provider services will become much more complex multi-provider services. And the competition policy and rules around how people can work together in order to provide a service and the rules that they then impose around access to their platforms or access to the data streams that they generate are going to be critical areas of focus for competition policy. Thank you.
Thank you, Peter. Are there any questions for Peter? Holly at the front here.
If we're thinking of access to facilities, what about access to things like clouds, access to things like data streams, access to things that you're talking about as, I suppose, the basis for money streams for revenue? Conceptually, how do you go from traditional access to facilities that we tend to think of as something tangible to access to things we think of as not tangible?
Well, I suppose the first question is, do you need to go there? And that gets to the discussion we had in the other room. Firstly, you can't go there to the extent that under the current access regime you're dealing with intellectual property, and intellectual property is involved in many of these applications, although there's some interesting questions around the limited application of copyright to data and whether data is in fact a form of intellectual property protected by trade secrets. Is that intellectual property for Part 3? There's some debates around that. But I think the key point is that the traditional tools of Part 4 economic analysis can be used in this space. But they're a lot more tricky to use because many of them will be two-sided markets. And we have very limited experience in applying through the law, economic analysis of two-sided markets. And I think that's been key as to why it's taken the European Commission now, what is it, over a year, to come to even an express view about the Google case. I just think they're thrashing around, frankly. So I'm certainly not advocating access regimes. I guess what I'm saying is that many of these commercial models that I'm now seeing do require the imposition of restrictions about who is involved in the service delivery model in order to make the model work. But then you have the question of, well, how do you police those restrictions and whether they are fair and beneficial for consumer welfare? And I think that's a question more about part 4 than about fiddling with access regimes.
Any other questions of Peter?
He's troubled.
Strong.
Peter, you've touched upon this already, but could you just project a little bit further down the track of the multinational character of so many of the players involved in the digital competition or otherwise, as recently highlighted in debates about taxation? Are there any parallels as to how some perfectly philosophically and legally drafted Australian competition law regime might front up to a global player?
Well,
Sorry, a group of global players.
yeah, look, I think it's extraordinarily difficult in the case of a Google or Facebook, which is, you know, a very large corporation in its home jurisdictions, which really are Europe and North America. I think the problem can be well illustrated by, as you think about new applications like Fitbit, health monitoring devices. Fitbits are actively marketed in Australia. When I put a Fitbit on and connect up to Fitbit, I deal with an organisation in California that has no physical or business presence in Australia other than sales to distributors in Australia like JB Hi-Fi, where I might have bought my Fitbit. The terms and conditions that I sign up to are Californian terms that purport to have exclusive arbitration in the courts of Santa Clara or wherever. And if Fitbit engages in anti-competitive conduct in the Australian market, how does the ACCC touch that? There's a case at the moment, I can't remember the name of the case, a consumer protection case. Yeah. And there the defendant is alleged to have contravened the consumer protection provisions in the Australian consumer law by doing business in Australia, but it has no points of physical presence, I think, in the doing of that business in Australia. But clearly when the ACCC case is that they knew that they were selling to Australian consumers. Look, I think in this interconnected global world that we live in, where distance is irrelevant, particularly a big data world where a lot of the analytics activities can be occurring in distant jurisdictions that are effectively interconnected into Australia as though they're in Australia but elsewhere. We can't have the ACCC purport to be the policeman of the world, and we're going to have to see increasingly close cooperation and coordination of activities of competition authorities. And that of itself is a reason for Australian competition law, I think, not to stray too far from European and North American norms. You know, concepts of misuse of market power, we can cook up all of the elaborate stuff that we like in Australia, and it's all kind of irrelevant, other than for an increasingly small sector of the Australian economy, because a growing sector of that economy will be effectively regulated offshore and can't beyond the immediate jurisdiction of the ACCC. So I think competition policy needs to pay very careful heed to overseas norms. I agree with Louise that it's insane that we do things like negotiate copyright as though we are as much a copyright exporter as an importer. That's clearly rubbish, and we should put Australia's interest first. But coordination is going to be more important to regulating competitive conduct in the future than it's than it's ever been in the past.
Okay, well,
Can I just make some comments in Hi, my name is Gloria Wong. I'm from the Australian Competition and Consumer Commission. I thought I'd just respond very briefly to some of the comments that Peter has made. It's not directly relevant perhaps so much to the particular topic about some of the issues that have been discussed, but just wanted to let people know that the Commission is very conscious of the real importance of basically coordinating both the enforcement activities as well as the policy development in relation to foreign jurisdictions. And there's certainly a lot of activity going on, which is perhaps not so well known to people outside the Commission, that particularly there are some big investigations happening where there's a lot of discussion with both Europe and America, particularly in that sort of space where talking about financial stuff where there's certainly activity overseas as well. And in terms of the Valve Corporation case, perhaps that's a good illustration of the fact that the Commission doesn't shy away from those cases where it considers that there might be some jurisdictional challenges, and certainly in Valve's case, they've definitely put up all those jurisdictional arguments we expected them to make. But certainly from the Commission's point of view, we certainly take the view that they supply these computer software products into Australia to Australian consumers, that companies should not see themselves as being somehow outside of Australian law when they do that, and the Commission is very, certainly very diligent in trying to make sure that they too abide by our laws. So I just wanted to respond briefly to that.
Sure. One more, and then Jane.
Thank you, Pete. Peter, you've mentioned a very important point about data being more important than transactions. Like you cited Google Wallet as an example, right? Now, I want to get your views on what you believe is the top policy principle that the government can consider for data to effectively contribute to the digital economy.
That's a hard question. Look, I think probably the most important thing is to understand that data is an incredibly fungible product. And by that I mean it's reusable in a wide range of applications that for example, personal data depersonalised can be used for many social goods and in ways that can increase consumer welfare. That big data is neither unalloyed good or unalloyed bad. It depends entirely on how it's used, and that we need to develop a much more nuanced view of uses of data, and I think a lot of that will have to rely upon contract and competition scrutiny of contracts as and when required for anti-competitive effect. But I'm a great believer in letting the market operate and understanding that data is kind of the oil of the digital economy, and that its repurposing and reuse can often be done in ways that's privacy protective, that respects intellectual property rights, and from which society derives benefit.
Thanks, Peter.